Hi, my name is Wanda Rochelle, and I'm a licensed realtor and probate specialist here in Georgia. Welcome to my channel. You are in for a treat today. Today, I have a special guest with me today, and we are talking about how to remove someone from your deed. My special guest today is none other than attorney Rhea Johnson. And so I'm going to allow her to introduce herself to you. Welcome, Attorney Johnson.
Hello. Thank you so much for having me on today. I'm delighted to be with you. I am a real estate and estate planning attorney here in Georgia. And so my background in estate planning, I think, will be extremely helpful to you and your client base. We can see both sides of the probate and how it intertwines and the nexus between probate and real estate. So I'm here to answer any of your questions to make the process smooth for your clients.
Awesome. Thank you so much for taking time out of your busy schedule to do this. I asked you maybe 2 days ago, and you were like, you came on board saying, and I didn't expect you to be able to do it so soon. So again, thank you so much. So we're going to go ahead and get right into it. Again, the topic today is how to remove someone from your deed. And so me being a probate realtor, a lot of times at closings, I see different scenarios as to when someone or why someone would put a person on their deed. Of course, if they're a couple, if it's a spouse, sometimes I see a girlfriend may place her boyfriend on the deed. What are some other scenarios that you see?
Well, generally, most people have two people on the deed because if they are financing their deal and both people are used to qualify for the loan, then both people will go on the deed as long as, both parties are in agreement. They both go on at the time of the purchase. Sometimes it could be that a person may not necessarily want mom to be on their home, but they needed mom to qualify for the loan. So at closing, mom goes on title and also goes on the security deed for the lender's purposes. So it happens there. But yeah, it normally is some type of relationship between the parties, husband, wife, parent, child, and sometimes couples do it too.
Okay. What I see a lot in my experience is sometimes the girlfriend is purchasing the home. Her name is the only name on the mortgage, and she desires to place her boyfriend on the deed. And so, of course, she's able to do that. It happens at closing. They come to the closing, a cute little lovely couple, and the boyfriend signs, and now his name is on the deed. Well, I get this a lot. Believe it or not, 5 months later, the girlfriend calls me and says, we broke up. What do I need to do to get his name off of the deed?
Oh, okay. So that it could be a very sticky situation. And I will say this as clearly as I can, just because this is not something that I would ever advise anyone to do. Adding someone to your deed is not something that you would do lightly, especially if you're financially bound to it. And sometimes what it happens is that the qualifying person, it could be girlfriend, but then the person that's actually paying the bills every month is boyfriend. So boyfriend wants his name on title also. So he's contributing financially to that resource for the mortgage. So the idea is, though, if a person is on title with you, they have the right to a half interest of that asset. So it doesn't really matter if they contributed to the mortgage or not. Once the person goes on title with you, they are 50% owner. And unless they agree to relinquish that particular interest, you may have a situation where in order to remove their name from title, you may have to pay them. Now, logistically, the process by which you do it is through a deed transfer. It may be a quitclaim deed in that instance, or it could be a warranty deed, depending on how the process takes place. but it's a deed transfer is what would be needed to take the boyfriend off of title. But again, he has an interest in the home, and it's not always that easy.
Mm-hmm. So obviously, if the boyfriend is not willing to do that, then it won't happen.
Well, it won't happen like that without some legal action. So you can do a legal action to partition your interest in that real estate. So it's a superior court action to partition the interest. However, a court may tell you very clearly, you need to pay him his interest because he's a part owner at that point. You know, the court is definitely not interested in helping people to make good decisions when they make bad decisions like that. You have to suffer the consequences, and legal ignorance is just not a defense.
Wow, wow. So I'm glad we're doing this video, and for those of you that are watching, I encourage you to subscribe, click like, and share the video, because I'm pretty sure most of my clients did not know that when we were, you know, when they were purchasing the home. So we need these videos so that we can educate people. Let's talk about if it's a spouse that is, if it's a situation where it's a spouse and the person is divorcing, because I know in those instances, I'm assuming it depends on what is outlined in the divorce decree.
Right. So when people are married and they have a marital residence where they both went on title together, and now they are separating and doing a division of assets, a court can decide, or the parties can agree doing a settlement of who's going to take what and what percentage of what property and interest will be devised. At that time, however, if they're represented by counsel, counsel should be making sure that the language in that divorce decree is very specific. Most of the time, the attorneys present the actual order, the actual divorce decree order for the judge's signature. So we are the ones that actually do it. The judge normally signs it. Some courts, of course, a court may draft their own order. But the point I make is that, you know, the attorneys do have an opportunity at that time to make sure that the language reads properly. And ideally, you want the language to specify if a person is entitled to the full interest in the home, and the divorce decree actually says that by order of the court that the property now is transferred to the remaining spouse. If they don't put that very language in it, and it just says vaguely, the marital residence shall go to Jane. All right, that's the wife, shall go to Jane. But it doesn't specifically say by virtue of this order, the property hereby vests in Jane. So even though it may say that Jane is entitled to it, a lot of divorce decrees require the husband or wife to go and sign a deed transfer. And that little moment in time just never actually happens.
Mm-hmm.
That husband or wife, either they pass away, it happens, or when it's time for them to sign the deed, they just won't do it. And then you have to go back to the court and do some type of enforcement action to get them to sign the deed. But an actual divorce decree can be your deed if it is written in a particular way to transfer ownership to that remaining spouse.
Wow, that's good information. I'll say for me, and I don't mind sharing this, I am divorced. And when I got a divorce, my ex-husband simply signed a quitclaim deed to release his responsibilities from the home or whatever. And so it was a simple process. I'm pretty sure from what you're saying, it's not necessarily as simple for other people. But so while we're talking about that, can you explain a quitclaim deed, exactly what it is? And you know what I noticed? I didn't even know this until I actually had to do my own quitclaim deed. It is quit with the T and not like the word quick.
Mm-hmm. Yeah, so a quitclaim deed is a type of deed transfer where a person is transferring their interest to another. So quit, yes, you know, that's the language. But really and truly, a quitclaim deed means that I give you my interest in this home without any warranty. That's what a quitclaim deed is. So in a lot of instances, Depending on how a quit claim is done, you may lose a warranty that you get at closing. So you get a warranty from the person that you purchased the property from. And if you continue to transfer with a warranty deed is one thing, but once you do a quit claim deed, you may lose that third party warranty. So that's just something to be mindful of. Quit claim deeds typically come without any title research, any title examination. So once a quit claim deed is done, if that person, for example, say the husband has tax debt and there's a lien that's been placed against your home, all right? You may not even know that. He'll quit claim his interest off of the property, no longer has any ownership or ties to it, but that lien that was with him at the time attached to that property and it's still there. So, you know, these are just some of the things that that can happen, and it doesn't change that somebody wants to transfer their interest, but at the time that you're doing it, you want that person off of your title. So you just quit claiming it.
Right.
Do that, you still don't necessarily know what is already attached to it. So you might quit claim him, but you can't quit claim his liabilities.
Wow. Well, thank God in my situation, he didn't have any liabilities. So we didn't have that issue, thank God.
Yeah.
Let me ask you this though, because just how I just said, I did my own quit claim deed. Do you suggest that people contact an attorney to have a quit claim deed done, just so you can make sure, you know, like you just said, there's not any liens or anything attached?
Yes, I always suggest that people contact an attorney to do any type of deed transfer. And the reason I say that is because, not just because of the title exam, we have clients that reach out to us and they want a quit claim deed. We'll draft a quit claim deed only if they ask us to do a title exam when we do one. So those are called draw deeds only. We just draft up the document, the language is there. The main thing is that we're doing is taking whatever interest the person that is transferring their interest, that person's interest is the same interest that's being transferred to that next person. So what I mean by that is, if there's a legal description on the previous deed, we make sure that that same legal description is what's being transferred. Now, keep in mind, if there are errors in a legal description on a quit claim deed, they typically will not be something that will be discovered because there's no title examination being done. So if you have, for example, an error in the deed that you received from the seller at closing, and then you decide to quit claim an interest to someone else, when you transfer that interest, if you're coming through us and you say, I want to quit claim, we're going to give that person that you're giving it to the same interest that you had. And if that interest is defective, then the interest to that other person is also going to be defective. So that's one thing that happens. Like I said, with quit claim deeds, there's no title, but everything else will be there. So the names will be properly listed. We will make sure that, you know, it's witnessed like it should be and notarized like it should be, and that it's recorded like it should be. And I will tell you, a lot of times people do quit claim deeds on their own. The language is not in the deed like it should be. Some people believe that they're transferring their interest to another person, but with the way they write it up, they never truly relinquish their interest because they didn't do it right. And then the last piece of it is sometimes these deeds never get recorded. So when we get to closing, people are like, I have ownership, it's right here. They'll bring us a deed and say, this person signed it over to me. And I tell them it's never been recorded. And now we got all these 3, 4, 5 things that's jumped in front of you. So it's just not as simple. So going to an attorney for a lot of reasons is definitely
the best option.
The best option.
Wow. Now because I'm a real estate agent, and I realize this video, you know, people may come across this video just searching the internet. I know what a title search is. That's only because I'm a real estate agent. So can you even explain what a title search is?
Yes. So a title search is done by a title examiner, someone who's versed in looking at the real estate records, the ones that we can see online and the ones that we can't see online. So they actually go to the courthouse, they review details. When they see that there's a probate or an estate in that title chain, they will then research and see what the probate records show. Someone may be the owner or maybe the estate representative, someone who's deceased. But the will specifically said that the property should be left to A, B, and C, but now the property is owned by D because the owner or the representative of the estate transferred it to D when the will really said it should go to B and C. So these are some of the things that a title examiner will look at. They'll look at the will if it's available. They'll look at the probate records, and they will see the chain of title to make sure that there are no breaks in the chain. So this person vested, and then this person legally and properly gave their interest to the next person, and then that person then gave their interest to two people who then one passed, and then one person was the surviving spouse, and so they follow the full chain. And then the legal description is also that they're looking every single deed. They're looking to see if that legal description was the same. When they see that there's something wrong with it, then they'll say, hey, this legal description showed plat A or plat 2, and this one showed, plat B. And so there's a discrepancy. And so they kind of, shine a light on things that are not good. We have to, as attorneys, investigate further when we see those things. Sometimes we have to go back to the examiner, ask them to look a little deeper. But then also we talk to the people to see if they can help us identify why these breaks happened. And if so, we can repair them, then we do. But it's a process. So it's real work that title examiners do.
Yes,
and
it is.
They
Wow.
should take advantage of it. It's a small cost, unfortunately, I have to tell you, to pay to have a title exam done than to wait 10 years and find out that you really don't have the interest that you thought you had.
Wow.
Mm-hmm.
Wow. Thank you for this information. As you can see, everyone watching, it's best to seek legal counsel. I will make sure that Attorney Johnson's information is in the description area. She's an amazing attorney here in Georgia. And I want to make sure we let everyone know that your practice is with your husband, correct?
Absolutely. Yes, it is.
What's his name?
His name is Emil Johnson.
Awesome. So just to sum it up, to remove someone from a deed, you definitely want to make sure that you seek legal counsel. Look, I'm a prime example. I did a little simple quick claim deed, thank God, my ex-spouse didn't have all of those expenses or liens or whatever, but you definitely want to make sure that you seek legal counsel. Is it anything else that you want to add today, Attorney Johnson, about this topic?
I would just also just kind of briefly mention businesses and trusts. A lot of people are interested in putting their property in their business name or in their trust. And so we get those calls quite often. And generally, putting a property in the name of your trust, if you have already established a trust, is something that's recommended because you want the trust property to flow through your trustee in life and then also in death. And it keeps you from having to go through probate. However, the complication comes in where people take out a loan for their property, and the lender expects that they're loaning the money to you. And now you're transferring your interest to a business entity. You're transferring your interest to a trust, and you're no longer the owner of the property. So generally, these are things that you want to get some approval from your lender, but if not, when you make these transfers, if you do it through an attorney, they can make the transfer somewhat limited to that mortgage interest or that loan interest. And so that puts it on the record that the person that's taking the interest or the entity that's taking the interest is taking it with the understanding that there's still a loan out there. We don't do those transfers from people to people, but we will do it from a person's personal ownership to a business or a trust, because technically they are still behind the business or the trust. The only consideration that we also, feel that they really need to be aware of is that any type of homeowner's insurance that they have is in the name of that person. So when they transfer that property to a business or transfer it to a trust potentially, the homeowner's insurance is not covering the business. They're not covering the trust. And you need to go back to that homeowner's insurance agency and add them as a payee on that policy, or you may need to take out a new policy. Because if something happens, you don't want the insurance company to say the owner of this property is not who we issued our policy to. So these are just some of the things. People are so quick after they get a lender to finance the deal. I want to do all these things. I want to take mama off of it. And I'm like, well, no, you can't take mom off of it, because mom was the reason that you got this deal. The lender advanced you the funds because of mom. So if we remove mom, you know, the lender might not approve. So these are just some of the things to know, is that when you have a mortgage, you have to really be careful about how you transfer interest and do things, because the mortgage security deed says that you cannot transfer your interest without the lender's approval.
Wow. Wow. So much knowledge. So much knowledge. Thank you so much. Again, my name is Wanda Rochelle. I'm a licensed realtor and probate specialist here in Georgia. And I hope that you all have learned a lot today. Again, I will have Attorney Johnson's contact information in the description area. And even if you're not in Georgia, you may be in another state. Do you have resources where you can maybe refer them to other people in other states?
We do have some connections with other state attorneys. I will tell you that Georgia is a little different from a lot of states. South Carolina is another attorney state, but there are plenty of states that are not attorney states. And so title companies tend to do that work, and they're not as, you know,
they're not attorneys.
Thorough. Yeah, so that's one of why Georgia is very careful to continue to be an attorney state, because they want the real estate records to be clear. So the language and the information that I share in Georgia may not be the same, but we will definitely do our best to refer them to a qualified specialist in their state.
Awesome. Thank you so much for joining me today. Please, I encourage you all to subscribe to the channel, and also click like and share. And if you have any questions, feel free to post a comment or question below. We'll be glad to try to get the information, the answer for you. Thank you again. My name is Wanda Rochelle, and I'll see you on the next video.